If you've been seeing alarming posts on social media claiming that Texas just passed 3 new immigration bills that will lead to mass deportations, that local police can now arrest anyone who looks undocumented, or that these new laws mean immediate enforcement starting this week, I need you to stop and take a breath, because while it is true that 3 immigration-related bills have been signed into law in Texas, most of what is circulating online right now is either exaggerated, taken out of context, or completely misrepresenting what these bills actually do and when they take effect. You are not alone in feeling confused or worried, and I'm going to walk you through exactly what these 3 bills say, who is actually affected, what is rumor versus fact, and most importantly, what you should do right now to protect yourself and your family without falling into panic. Welcome to Immigration Law Alerts, where we give you clear, factual immigration information without the fear or the hype. So let's start by addressing what actually happened. In early 2026, the Texas state legislature passed 3 bills related to immigration enforcement and border security, and the governor signed them into law. These bills are state-level laws, meaning they apply only within the state of Texas, and they do not change federal immigration law. This is an important distinction because immigration law in the United States is primarily a federal matter governed by agencies like U.S. Citizenship and Immigration Services, Immigration and Customs Enforcement, and Customs and Border Protection. States can pass laws related to immigration enforcement, but those laws must operate within the boundaries of federal law and the U.S. Constitution, and they are often subject to legal challenges in federal courts. The 3 bills that were passed are commonly referred to by their bill numbers, and I'm going to explain each one in simple terms so you understand what they actually do and who they affect. Before I dive into the details, let me clarify what these bills do not do. They do not create a new immigration system separate from federal law. They do not give Texas the authority to deport people. Deportation is a federal immigration process that only federal authorities can carry out. They do not automatically make it legal for police to stop anyone who appears to be an immigrant without any other legal reason, and they do not go into effect immediately in all cases. Some provisions have delayed implementation dates, and some are already being challenged in court, which means their enforcement may be blocked or limited. Let me now explain each bill one by one. The first bill, which I'll refer to as Bill 1, expands the authority of certain Texas law enforcement officers to cooperate with federal immigration authorities. Specifically, it allows Texas Department of Public Safety officers and certain other state law enforcement agencies to inquire about immigration status during lawful stops or arrests, and to cooperate with ICE in detaining individuals who are believed to be in the country without authorization. This bill also provides legal protections for law enforcement officers who participate in immigration enforcement activities, meaning they cannot be sued or penalized under state law for cooperating with federal immigration authorities. What does this mean in practice? It means that if you are stopped by Texas State Police for a traffic violation, or if you are arrested for any reason, the officer may ask about your immigration status and may contact ICE if they believe you are in the country without authorization. However, this does not mean that officers can stop you randomly just to check your immigration status. The Fourth Amendment of the U.S. Constitution protects everyone in the United States, including people without legal status, from unreasonable searches and seizures, which means law enforcement still needs a valid reason to stop you, such as a traffic violation or reasonable suspicion of criminal activity. The second bill, which I'll call Bill 2, creates penalties for certain activities related to illegal immigration. Specifically, it makes it a state crime to transport or harbor individuals who are in the country without authorization if the person doing the transporting or harboring knows or should have known that the individuals are not authorized to be in the United States. This law targets human smuggling and harboring operations, and it carries significant criminal penalties, including potential jail time and fines. What does this mean for regular people? If you are driving a family member or friend who does not have legal status to work, to the grocery store, or to a doctor's appointment, you are generally not violating this law as long as you're not doing so as part of a smuggling or harboring operation for profit or to evade immigration enforcement. The law is intended to target organized smuggling networks and people who profit from transporting or hiding unauthorized immigrants, not family members providing basic assistance. However, the language of the law is broad, and there are concerns that it could be applied more widely, which is one reason why legal challenges have been filed. The third bill, Bill 3, increases penalties for certain crimes committed by individuals who are in the country without authorization. Specifically, it enhances sentences for individuals convicted of certain felonies if they are found to be in the United States illegally at the time of the offense. This bill also requires state courts to notify ICE when someone who is believed to be in the country without authorization is arrested or convicted of certain crimes. What does this mean? If someone without legal status is convicted of a serious crime like assault, theft, or drug trafficking, they may face additional penalties under state law, and they will almost certainly be referred to ICE for immigration enforcement. This bill does not create new crimes. It adds additional penalties to existing crimes if the person committing them is in the country without authorization. It also does not affect people with legal status such as green card holders, work permit holders, or visa holders unless they commit crimes that make them removable under federal immigration law. Now let me address some of the most common rumors and misunderstandings circulating about these bills. Rumor 1, police can now stop anyone who looks like an immigrant and demand papers. This is false. The Fourth Amendment still applies, and law enforcement needs a lawful reason to stop you, such as a traffic violation, reasonable suspicion of a crime, or a warrant. Officers cannot stop you solely based on your appearance, ethnicity, or language. If they do, that is a violation of your constitutional rights, and you may have grounds for a legal challenge. Rumor 2, these bills mean immediate mass deportation starting now. This is exaggerated. Deportation is a federal process that involves immigration courts, due process, and opportunities for legal representation and appeals. State laws cannot override federal immigration procedures. While these bills may lead to increased referrals to ICE, the actual deportation process is still controlled by federal authorities and follows federal law. Rumor 3, if you give someone a ride, you can go to jail. Misleading. The law targets smuggling and harboring operations, not ordinary acts of assistance among family and friends. However, because the language is broad, there is concern about how the law will be interpreted and enforced. If you are worried about this, consult with an immigration attorney about your specific situation. Rumor 4, green card holders and people with work permits are at risk under these laws. Mostly false. People with lawful permanent resident status, work authorization, or valid visas are not targeted by these bills. However, if you have legal status and you commit certain crimes, you could face immigration consequences under federal law, not because of these state laws, but because federal immigration law makes certain crimes grounds for deportation. Rumor 5, these laws go into effect immediately and are being enforced everywhere in Texas right now. Partially false. Some provisions of these bills have delayed effective dates, and several legal challenges have been filed in federal court arguing that the laws are unconstitutional or conflict with federal immigration law. In some cases, judges have issued temporary injunctions blocking enforcement of certain provisions while the legal challenges proceed. This means that enforcement is uneven and may be paused or limited in certain areas or for certain provisions. Let me now explain who is most affected by these bills and who is not. People at highest risk include individuals who are in the United States without legal authorization and who have interactions with Texas state law enforcement such as traffic stops or arrests, individuals who are involved in transporting or harboring unauthorized immigrants as part of smuggling or harboring operations, individuals without legal status who are convicted of felonies or certain serious crimes in Texas, and individuals who have outstanding removal orders or prior deportations and who come into contact with law enforcement. People at lower risk include lawful permanent residents with clean criminal records, individuals with valid work permits, student visas, or other authorized immigration status who comply with the terms of their status, U.S. citizens regardless of their ethnicity or country of origin, individuals who have pending asylum cases or other pending immigration proceedings and who are attending their hearings, and individuals who do not have interactions with law enforcement and who do not have criminal records. However, I want to emphasize that even people at lower risk should understand their rights and should be prepared in case they encounter law enforcement or immigration enforcement. Having legal status is the best protection, but even people without legal status have constitutional rights that protect them from certain government actions. Let me explain what you should do if you are worried about how these bills might affect you or your family. First, consult with a qualified immigration attorney or a Board of Immigration Appeals accredited representative. Do not rely solely on social media, rumors, or advice from unlicensed consultants or notarios. Immigration law is complex and your situation is unique. An attorney can review your specific circumstances and advise you on your rights and options. Second, know your rights if you encounter law enforcement. You have the right to remain silent, and you do not have to answer questions about your immigration status or where you were born. You have the right to refuse consent to a search of your car, home, or belongings unless the officer has a warrant. If you are stopped by police, remain calm, do not argue, and do not provide false information. Ask if you are free to leave, and if the officer says yes, calmly walk away or drive away. Third, carry important documents with you if you have them. If you have a green card, work permit, visa, or any other proof of legal status, carry it with you at all times. If you are stopped by law enforcement, showing proof of legal status can prevent unnecessary complications. However, if you do not have legal status, do not carry false documents, as using fake documents is a serious crime that can result in criminal charges and permanent bars to future immigration benefits. Fourth, create an emergency plan with your family. Identify a trusted person who can care for your children if you are detained. Make sure important documents such as birth certificates, passports, immigration papers, and financial information are in a safe place that trusted family members can access. Write down the contact information for an immigration attorney and make sure your family knows how to reach that attorney if needed. Preparing a plan does not mean that something bad will happen. It simply means you are being responsible and protecting your family. Fifth, if you are arrested or detained, exercise your right to remain silent and your right to an attorney. Do not sign anything without speaking to a lawyer. Do not make statements about your immigration status or your background without legal advice. Many people unintentionally hurt their cases by making statements or signing documents without understanding the consequences. Sixth, stay informed through reliable sources. Follow updates from official government websites such as USCIS, ICE, and the Texas State Legislature. Follow trusted immigration advocacy organizations and legal service providers. Avoid relying solely on social media posts or rumors from friends because misinformation spreads quickly and can cause unnecessary panic. Now let me address the legal challenges to these bills. Several civil rights organizations, immigrant advocacy groups, and legal aid organizations have filed lawsuits in federal court challenging these Texas immigration bills. The legal arguments include claims that the bills violate the Supremacy Clause of the U.S. Constitution because they attempt to regulate immigration, which is a federal responsibility, that the bills violate the Fourth Amendment by encouraging unlawful stops and searches based on racial or ethnic profiling, that the bills violate due process protections by imposing penalties without adequate legal safeguards, and that the bills conflict with federal immigration law and therefore cannot be enforced. In some cases, federal judges have issued temporary restraining orders or preliminary injunctions that block enforcement of certain provisions while the lawsuits proceed. This means that even though the bills have been signed into law, they may not be fully enforceable at this moment, or they may be enforced inconsistently across different parts of Texas. Legal challenges can take months or even years to resolve, and the final outcome may involve appeals to higher courts, including potentially the U.S. Supreme Court. What does this mean for you? It means that the situation is fluid and enforcement of these laws may change as court cases proceed. It also means that just because a law has been passed does not mean it will necessarily be upheld as constitutional or enforceable. Courts play a critical role in reviewing laws to ensure they comply with the U.S. Constitution and federal law. And in cases involving immigration, federal courts have frequently struck down or limited state laws that overstep federal authority. Let me now provide some context about why these bills were passed and what the broader debate is about. Immigration policy in the United States is a deeply divisive political issue, and state-level immigration laws are often passed in response to frustrations with federal immigration enforcement or border security. Supporters of these Texas bills argue that the federal government is not doing enough to secure the border or enforce immigration laws, and that states have the right to take action to protect public safety and uphold the rule of law. Opponents argue that immigration is a federal responsibility and that state laws like these undermine federal authority, lead to racial profiling and civil rights violations, and create confusion and fear in immigrant communities. I am not here to argue one side or the other. Immigration Law Alerts focuses on explaining what laws say, how they work, and what they mean for people navigating the immigration system. It is important to understand that immigration enforcement is not just a legal issue, it is also a human issue that affects millions of people, including families, workers, students, and communities. Whether you support or oppose these bills, it is essential to base your opinions and actions on accurate information rather than fear, rumors, or misinformation. Before I close, I want to address the emotional toll that news like this creates. Even if you are not personally at risk, hearing about new immigration laws and increased enforcement can trigger anxiety, fear, and stress, especially if you or your family members have uncertain immigration status. This fear is real and it is valid. However, fear should not prevent you from understanding your rights, seeking help when needed, or living your life. Immigration Law Alerts exist to provide you with calm, factual information so that you can make informed decisions. Immigration rules and enforcement priorities can change, but they rarely change overnight, and due process protections exist. If you have legal status, maintain it by complying with all requirements. If you do not have legal status, consult with an attorney about whether you may be eligible for any form of relief or protection. If you are worried about enforcement, know your rights, have a plan, and stay informed through reliable sources. If this video helped you understand what is actually happening with the 3 new Texas immigration bills, who is affected, what is rumor versus fact, and what you should do, I'd appreciate it if you subscribe to Immigration Law Alerts and turn on notifications so you stay informed with calm, factual immigration updates. Share this video with anyone in your community who might be worried or confused, and if you have specific immigration questions, leave them in the comments. I can't give personal legal advice, but I can cover common questions in future videos. Thank you for watching, and remember, stay informed, know your rights, verify information before believing it, and if you need legal help, consult with a qualified immigration attorney.